There are reports from immigration lawyers in my network that their clients who are in removal proceedings applying for asylum and who have a final court date scheduled, it's called an individual merits hearing, are being called in to ICE appointments and being detained at those ICE appointments, or are otherwise just being arrested outside of their homes and detained. We are trying to figure out what exactly is going to happen with all of these clients. And the prevailing theory at the moment is that the ICE officers are going to try to transfer the case from the normal immigration judge to one of the judges who's in charge of the detained docket, and then ask them to dismiss removal proceedings so that ICE can issue an expedited removal order and just deport those people without having them have an opportunity to present their asylum claim and have a chance of actually winning their case. It's unclear exactly what reaction there will be from the immigration legal community in response to these, whether there's going to be some sort of class action or individual case by case attorneys challenging these things in higher courts. But this is a pretty dirty tactic, and it all depends on the Department of Homeland Security's ability to issue expedited removal orders. In these postings by immigration lawyers in my group, there have been discussions about, well, how can they issue expedited removal orders if the person is in ordinary removal proceedings? Because the regulations and the Immigration and Nationality Act don't allow that. And the answer, or the theory right now, is they're gonna get the removal proceedings dismissed by a more favorable immigration judge, which, the judges in detained immigration courts tend to be more favorable. And by the way, ICE can choose to detain somebody who's in removal proceedings. Now, whether or not that person will remain detained is yet to be seen. That person would have a right to apply for a bond redetermination hearing with the immigration judge and possibly be released yet again. But it's going to depend on which immigration court and which judge, and whether that judge is favorable towards immigrants or is, in some jurisdictions like Lumpkin, Georgia, these judges will deny 95% of immigration cases and order deportation orders in almost all of those cases. Whereas in New York, I don't have the exact numbers in front of me, but it's closer to like 50%. So wide variation based on which venue, which location you're attending immigration court. If the Department of Homeland Security attorney can get the immigration judge to dismiss the removal proceedings, and basically, the person has no more ongoing removal proceedings, no more immigration court, and that immigrant entered the US within the past 2 years, then the Department of Homeland Security can use their authority to expeditiously remove that person. In expedited removal proceedings basically just requires the signature of an ICE official saying that you're being expeditiously removed from the United States. It's another way to get a removal order. So this authority is how the Trump administration is trying to bypass the immigration courts. And yeah, it's yet to be seen what pushback there will be from the federal courts, especially for people who are seeking asylum in the United States, because under international law and US law, they have a right to remain in the US until a final decision is made on their asylum case. So I'm very curious to see what the outcome is going to be for these specific cases. If you guys want to stay up to date on all of the immigration news that's coming out of the Trump administration, be sure to subscribe. If you personally need any assistance with the removal proceedings, an asylum application, or what we actually focus on is family-based immigration and naturalization, I would love to speak with you. You can find my information in the video description below, and I'll see you guys next time for another video.